Your green card application has been in process for 2 years. You are months from approval. Then the news hit. DHS just announced that people in the adjustment of status pipeline must leave the United States and apply at a consulate in their home country. Before you book that flight, you need to hear this. For a significant number of people receiving this news right now, leaving is the one action that cannot be undone. Federal immigration law has a provision about unlawful presence that activates at the moment you cross that border. 180 days of unlawful presence and you leave, you have a 3-year bar. 1 year or more, 10 years outside of this country. 10 years away from your job, your family, and your home. Because you did what the government told you to do. That's not an accident, that's the design. In the next 9 minutes, I'm going to walk you through who this memo actually affects, how to find out whether your status history has gaps you do not know about, and the one action you cannot take until you do. Here's what happened. On May 21st, DHS announced that people already inside the United States on temporary status must now leave the country and apply for their green card through consular processing. That means at a U.S. embassy or consulate in their home country. This affects people on H-1B work visas, people on F-1 student visas, and OPT, people on tourist visas who married a U.S. citizen and built a life here, people in marriage-based adjustment cases who have been waiting here and are months from their approval. Hundreds of thousands of people currently in the adjustment of status pipeline. Let me explain what adjustment of status means because this is where everything turns. When you're already inside the United States and you want to become a permanent resident, the standard process is to file an I-485. That is the adjustment of status. You stay in the country, you wait, you go to your interview, you get your green card without ever leaving. This is not a loophole. Congress created this pathway, and millions of families have used it legally. H-1B workers whose employers sponsored them. International students who graduated, got job offers, and stayed. Spouses of U.S. citizens who entered on a tourist visa, got married legally, and have been following every rule since day one. What DHS just announced is that most of those people can no longer use that pathway, or at least have to show that they warrant discretion in order to use that pathway. They have to leave, go home, apply at the U.S. consulate, and wait there unless the officer exercises discretion for them. That might sound like a bureaucratic detour, annoying but manageable. This is exactly what they want you to think. Here is the trap, and you need to understand this completely before you make any decisions at all. Federal immigration law has a provision about unlawful presence. If you have been in the United States without legal status, or if your status lapsed at any point, even briefly, even accidentally, there are severe consequences to leaving the country. If you accrued more than 180 days of unlawful presence and then you leave, federal immigration law triggers a 3-year bar. You cannot come back for 3 years unless you obtain a waiver. If you accrued 1 year or more of unlawful presence and you leave, that bar is 10 years without a waiver. 10 years outside of the country, 10 years away from your family, your job, your home, your life, because you did what the government told you to do. Think about that for a second. The Trump administration is telling people to leave and apply abroad. And for a significant number of the people receiving this news right now, the act of leaving will activate a federal bar that locks them out for years. They complied, and complying is what ruined them. That is not an unintended side effect. That is the design. You say, Kate, but I've been here legally. My employer has filed every petition on time. I'm on H-1B. I've never had a gap. This doesn't apply to me. Maybe. But the unlawful presence calculation is more complicated than most people realize. H-1B status can lapse in the gap between an old approval expiring and a new petition being approved. F-1 students who transition to OPT sometimes had processing periods their school didn't handle correctly. People whose I-485 was denied and then refiled may have accrued unlawful presence between the two filings. People on B visas who overstayed by even a few weeks may have triggered a clock they didn't know was running. This is not a question you can answer by reviewing your own paperwork. It requires a full legal analysis of your complete immigration history, every entry, every status change, every gap, including the ones you might not know about yet. Now let me show you the other side of this trap, because there are two sides and both of them are dangerous. Let's say you've done that analysis. You entered legally, you've maintained status perfectly, 0 unlawful presence. You're thinking, fine, I'll comply. I'll go through consular processing. What's the actual damage? Here's the damage. Consular processing abroad means you are outside the United States while you wait. For preference category applicants, H-1B workers sponsored for a green card, family preference categories, that can mean years of separation. Even for immediate relatives of U.S. citizens who face no visa backlog, consular processing adds months of uncertainty while you sit abroad. Your H-1B employer cannot hold your position indefinitely. Your U.S. citizen children are growing up. Your mortgage, your lease, your business, your career, everything you've built here legally by following every rule gets placed on hold or dismantled because this administration issued a memo that, by the way, is already being reviewed for legal challenge. 3 instincts kick in when people hear this news. Comply and leave. That instinct destroys you if your unlawful presence analysis goes the wrong way. Wait and see. That instinct costs you time and options you will not get back. Or assume your pending case is unaffected. That is the most dangerous assumption of all. Pending cases are not automatically protected by a filing date before this memo dropped. You do not get on a plane. You do not notify your employer that you're leaving. You do not file anything new or withdraw anything existing without legal counsel reviewing your full situation first. What you do is get in front of an immigration attorney today, not this week, today, and have your complete immigration history reviewed. Every entry, every form, every status, because your specific exposure determines everything. And the answer for someone with 0 unlawful presence is completely different from the answer for someone with 6 months. If you have already talked to your company's immigration firm and they said your case looks fine, that conversation could have happened before this memo. The legal landscape changed on May 21st. Get a second look from an attorney working on these cases right now. This policy is not settled law. Immigration attorneys and civil rights organizations are already moving. Policies that looked permanent 6 months ago have been paused or blocked already by federal courts. That is not a guarantee this one will be paused or blocked, but it is a critical reason not to take an irreversible action before you understand what the legal landscape looks like in 30 days. The families who call first have options. The ones who leave first before they understood their exposure close doors that cannot be reopened. The panic is part of the strategy. They want you to move fast and move wrong. Your immigration case is a legal process. It is hostile. It's deliberately confusing. And this administration is counting on that confusion to do what legislation never could. But it is still a process, and processes have rules, and rules can be challenged. You still have options right now. Whether you still have them in a week depends on what you do today. If you are in the adjustment of status pipeline, if you have a pending I-485, if you are an H-1B worker with an employer-sponsored green card case in progress, if you are in a marriage-based case and have been waiting in the United States, you need legal counsel today. Go to Lincoln-Goldfinch.com to book a consultation. Do not leave the United States without talking to an attorney first. Do not assume your case is unaffected. Talk to someone who can look at your actual file today. Subscribe to this channel. I will be updating you as courts respond to this policy and as the legal picture develops, because this will move fast. And if you want to know what to do when immigration officers come to your door, because administration is not stopping with green card policy, watch this video next. I break down exactly what you are and are not required to do, what your rights actually are on U.S. soil regardless of your status, and how to protect yourself and your family in that moment.